So here's the actual elements of the offense for the driving part. No person to whom a license has been refused or whose license has been, or reciprocity privilege has been suspended or revoked, or who has been prohibited from obtaining a driver's license shall personally operate a motor vehicle during the period of refusal, suspension, revocation, or prohibition. So let's go through these things one at a time. First element that has to be proved is driver's status, okay? They're going to have to show that the defendant is in one of these categories. Either the driver's license was refused, the license was either suspended or revoked, the reciprocity privilege was either suspended or revoked, or the individual had been prohibited from obtaining a driver's license. So those are the only four categories that would put you on the revoke list. I want to talk first about reciprocity privileges that are suspended or revoked. There's two cases dealing with that. One of them is kind of old. One, a Bergen County case of all things, is relatively new. Judge, could you talk about the Profita and Colley?
Yeah, Colley is the Bergen County case.
Yes.
In fact, Judge Tesoro was just here. He had signed up for this course, but had to unfortunately go to a funeral. It was a Fort Lee case, and we actually talked about it, Judge Tesoro and I, before he decided it. It was a conviction in New Jersey for driving while suspended, but the defendant was a New York licensed driver and had been convicted in New York of driving while impaired. And the persuasive defense attorney tried to convince Judge Tesoro that he would plead his client guilty to the 340 if Judge Tesoro would agree not to impose an enhancement based upon the New York impaired conviction. And Judge Tesoro stuck to his guns and said, no, I'm not going to agree to that. I think the New York conviction applies and the enhancement therefore applies. And as a result, Judge Tesoro had to stay until midnight to try the case rather than get out of there 3 hours earlier with a nice, easy plea. And he ruled that he convicted the person of the 340, and he imposed the enhancement portion of it, and it was appealed to Judge Harry Carroll. Judge Carroll, I just talked to him about it yesterday. He affirmed Judge Tesoro, and it went to the appellate division, and the appellate division agreed that it was a proper use based upon the interstate compact. It was proper to use the New York DWI conviction as an enhancement to a New Jersey driving while suspended. There was an ancillary issue. Shall I go into that, the evidence issue? They tried to put in evidence the New York abstract in the New Jersey court, and there was an objection on the grounds that it was hearsay, and so there was an argument that it was a public record, but an out-of-state public record requires not only that it be signed by a person in an official capacity, but that it also be sealed. And the defense attorney was arguing that there was no raised seal on the New York abstract. And the appellate division said it doesn't matter. There's nothing in evidence rule 902 that requires a raised seal. It just simply requires a seal, and there was a seal in the background of this abstract, and it was signed in an official capacity. So the appellate division ruled that it properly went into evidence.
So this is a guy who has nothing to do with New Jersey at all. New Jersey is just a rumor to him. He's a New York domiciliary. He's a New York resident. He has a New York license, and he gets drunk driving in New York too. So New York has placed him on the revoke list for drunk driving. So far, he has nothing to do with New Jersey at all, except to have the poor judgment to come across the bridge one day and get stopped in Fort Lee, right? So now the issue is, his argument is, hey, I'm not on the revoke list for drunk driving in New Jersey. That's a New York conviction. And I think the statute actually says under this section, or words to that effect.
It says under 450, 39-450.
So you really have two things going on here. Number one, the court's recognition that his reciprocity privilege, his privilege to drive in New Jersey under a foreign license, is revoked at the same moment that he loses his license in New York State. And number two, which is even worse for the defendant, he's subject to the enhanced penalties he would get if this had occurred in New Jersey for drunk driving. In other words, 10 to 90 days in jail and the extra fine and things of that nature, okay? The Profita case, I'm going to ask you to just put it in your notes that this is one of the most important driving on the revoke list cases ever. And there's really two distinct legal issues in it, one dealing with injury and the second one dealing with this business about reciprocity. Could you talk about that a little bit, Judge?
Yeah, Profita was a case where the licensee was a New York licensee again, and he was suspended in New York. Michael Grosson, we were talking about this before. He was suspended in New York for failing to appear. He hadn't been convicted of anything, just failed to appear. So his New York license got suspended, and he came into Jersey, and he drove in New Jersey. New Jersey hadn't taken any kind of action, probably because he wasn't a New Jersey licensed driver. Nevertheless, he was stopped for driving in New Jersey for driving on the revoked list. And the issue was whether he really was in fact revoked or suspended. Those terms tend to be used interchangeably. Whether he was in fact suspended based upon the fact that New York suspended him for his failure to appear without New Jersey taking any action. The case goes into the history of 39:5-30, which authorizes the director of or the commissioner of the New Jersey Motor Vehicle Commission to suspend licenses, registrations, and that's been amended to now allow suspension of reciprocity. Nevertheless, even though that statute permits it, there was no action taken by New Jersey with respect to this person's driver's license. The court held, it didn't matter, that either way he was considered to be suspended. When he was suspended in New York, he was automatically suspended with respect to his reciprocity privilege, whether or not New Jersey took any action on it, and therefore the suspension in New York held up in terms of his driving while suspended.
And just to kind of complete the issue with Mike's case, my sense is that a good plea agreement on these cases, if the defendant can get his reciprocity privileges restored, which basically would be one of two things. First of all, get his problems taken care of in his home state. Sometimes it might also involve paying a restoration fee in New Jersey under certain circumstances. But regardless, if he can show that he's taking care of his problems in his home state and has reciprocity privileges to drive in New Jersey, a good plea agreement is 39-317, which is operating in New Jersey without touring privileges. It's much more preferable to 39-310 because, number one, the elements of 39-310-317 are very similar. The sentences are identical, but 39-317 doesn't have a surcharge. 39-310 does. It has a $100 year surcharge for 3 years. So if you're a prosecutor, you want to hold out this olive leaf to somebody, it's a good deal because you save $300, and it's self-evident why this would be good for defense counsel. The reciprocity privilege then is going to have nothing whatsoever to do with New Jersey. If the home state suspends the driving privileges, automatically that person no longer has reciprocity privileges to come into New Jersey and operate a motor vehicle. Now, the second way you can do this is by having your license suspended or revoked. There's a technical difference between a suspension and a revocation, and that's temporal in nature. The classical definition is that a suspension is going to be for a determinate period or an indeterminate period, whereas a revocation is permanent. In other words, you're never going to be getting your license or driving privileges restored. The problem is that both the legislature and in the case law, they use these terms interchangeably, okay? So, and in practice, it happens that way too. For example, in 39-531, where judges have the authority to suspend driver's license, well, they take your license away for willful violations of either, I think it's subtitle 1.
Any Title 39?
No, I don't think, I think it's just subtitle 1.
No, I don't think so. I think it says all Title 39. We'll check.
We're going to check that. Yeah. I'm trying to think something good to bet him on this. In any event, they use the word in the statute, revoke, okay? In other words, that it's the power of the judge or the commissioner of the DMV is to revoke the license for a willful violation, which if you look at it on the surface would mean, revoke means take it away forever. But that's not how it's done in practice. Normally the judges will impose a suspension term of, whatever it's going to be, a month, 2 months, 2 years, whatever, it doesn't matter. The point I'm trying to make here is that although there's a technical legal difference between suspension and revocation, they're used interchangeably, and the idea is that at some point the defendant will probably be eligible to get his privileges restored, either due to the passage of time, the payment of money, or both.
Bob, you may not be aware of this, but Judge McGeady has actually written an article on the difference between the use of the term revoked and suspended.
Now, what'd you say, Judge? I was not aware of that.
Yeah, when did I write? About 15 years ago, I think.
Oh.
It was back when dinosaurs roamed the earth.
It was published in the Barrister, which is the Bergen County Bar Association's legal publication, and it's too long to go into here. But I mean, I pointed out the distinctions and extended from there. When does the suspension go into effect? Does it go into effect immediately, or can it be postponed? Mm-hmm. We can get copies of it to you if you need it.